when the king exercises the right on the same people or same subjects. जैसे there is a law which imposes equal burden on all the people. A law which imposes equal burden on all the people. ठीक है. Similarly, law imposes equal favor on all the people. So law imposes favor as well as burden. Law imposes favor as well as burden. In case there is an encroachment, law imposes favor. Equality is imposed as a favor as well as a burden. And when there is an infringement, and when there is any infringement, लिख तो लिया है. आगे लिखो. Whenever there is an infringement, whenever there is an infringement by the state, 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 it is an obligation, or a burden on the state which can be enforced. It is an obligation of the burden on the state which can be enforced. ठीक है. रेसिडुआ में एक पॉइंट लिखो. जो हमारा इंटेलिजिबल डिफरेंशिया है ना, यूएस में इसी कंसेप्ट को स्ट्रिक्ट स्क्रूटनी बोलते हैं. यूएस में रीजनेबल क्लासिफिकेशन को बोलते हैं स्ट्रिक्ट स्क्रूटनी. strict scrutiny. The concept of reasonable रेसिडुआ में लिखो reasonable classification. It is refined with reasonable or strict scrutiny. Strict scrutiny. So reasonable classification is clubbed with strict scrutiny. Depending upon the basis of the classification, such as race, color, depending upon the basis of the classification such as race or color, yes, okay, the state must prove public interest. The state must prove public interest. The state must prove public interest for the purpose of justifying, the state must prove public interest for the purpose of justifying classification. For the purpose of justifying classification. ठीक है. कुछ और पॉइंट्स भी लिखो. Substantive law and procedural law. Substantive law, procedural law are both subject to Article 14. Substantive law and procedural law are both subject to Article 14. That is, classification should be reasonable. That is, classification should be reasonable both for substantive as well as procedural law. That is, classification should be reasonable both for substantive law as well as shall be reasonable both for substantive law as well as procedural law. Now write down a question. Can a single person be a class? Can a single person be a class? जिसको कहते हैं सिंगल पर्सन लॉज अंडर आर्टिकल 14, सिंगल पर्सन लॉज ऑफ सिंगल पर्सन लॉज ऑफ आर्टिकल 14, अंडर आर्टिकल 14। तो इसका आंसर हमने पहले ही पॉइंट में लिख लिया, दैट अ सिंगल क्लास, सिंगल पर्सन कैन बी अ क्लास इन इटसेल्फ। सिंगल पर्सन कैन बी अ क्लास इन इटसेल्फ। A single person can be a class in itself. The basis of the classification, हाँ, क्वेश्चन का आंसर लिखो, सिंगल पर्सन, हाँ, can a single person can be a class in itself, class in itself, can a single person be a class under article 14, या फिर सिंगल पर्सन लॉ अंडर आर्टिकल 14, सिंगल पर्सन लॉ अंडर आर्टिकल 14। इस पे बहुत इंपॉर्टेंट केस है चिरंजीत सिंह, चिरंजीत सिंह चौधरी, चिरंजीत सिंह है या चिरंजीत लाल है, चिरंजीत सिंह या चिरंजीत लाल चौधरी, ठीक है। सो सिंगल पर्सन लॉ अंडर आर्टिकल 14, ठीक है। इसका आंसर लिखो, लिखो क्लासिफिकेशन, द बेसिस ऑफ क्लासिफिकेशन कैन बी geographical, the basis of the classification may be different, the basis of the classification may be different, the basis of the classification may be different, example geographical, nature, trade or occupation, etc., trade or occupation, etc. Example, a tenancy law, a tenancy law may be required for only a part of the state. A tenancy law is required only for a part of state where their condition is very bad. A tenancy law is required only, a tenancy law is required only for a part of the state. A tenancy law is required only for the only for a part of the state where the condition of the tenant is bad. That is, it may vary from locality to locality. Similarly, if capitation fee is imposed on the students who are NRIs, similarly, capitation fee was imposed on, capitation fee मतलब जिसको कहते हैं डोनेशन, capitation fee is imposed on the students who are NRI students, who are NRI students of a state, because the state has to contribute, because the state has to contribute for effective functioning of the education institution, for effective functioning of the education institution, effective functioning of the education institution. In Chiranjit Lal Chaudhary versus Union of India, in Chiranjit Lal Chaudhary versus Union of India 1950, sorry, 1950, Chiranjit Lal Chiranjit Lal Chaudhary, चाचा चौधरी थे ना वैसे, चिरंजीत लाल चौधरी वर्सेस यूनियन ऑफ इंडिया 1950, a single individual may constitute a class. It was held a single person may constitute a class A single person may constitute a class for the purpose of Article 14. For the purpose of Article 14. So वही केस है शोलापुर केस. In this case, the management of in this case the management of a company in Sholapur. In this case, management of a company in Sholapur was taken away by the government, taken over by the government by passing Sholapur Spinning Act. By passing Sholapur Spinning Act. Spinning Act. चिरंजीत लाल चौधरी है वो भी. ईयर कौन सा था? 1950. मे बी अलग से, क्योंकि मैंने तुमको अगर या तो मैंने बुक से पढ़ाया या तो मैंने डाइजेस्ट से पढ़ाया. तो डाइजेस्ट में कई बार ऐसा होता है कि डाइजेस्ट में जैसे मेनका गांधी केस बता देना एक बार. ठीक है. सो द मैनेजमेंट वॉज टेकन ओवर बाय द गवर्नमेंट अंडर दिस एक्ट. आगे लिखो. by passing the Sholapur Spinning Act. By passing the Sholapur Spinning Act, the act was challenged on the ground. The act was challenged by the shareholder. The act was challenged by the shareholder on the ground that single company, that a single company and its shareholder are denied equality. That a single company and its shareholder are denied equality before the law. Because there is a differential treatment. Equality before the law because there is a differential treatment. Because there is a differential treatment. Because there is a differential treatment with respect to other companies, and their shareholders, other shareholders, other companies and their shareholders. Full stop. Law has selected one company arbitrarily. Law has selected one company arbitrarily. Full stop. Answer लिखो. It was held. The act was held valid. देखो, the act was held valid. The act was held valid. A law may be constitutional. The law may be constitutional even though it applies to a single individual. The law may be constitutional even if it applies on a single individual. The law may be constitutional even if it applies on a single individual. That is on account of similar circumstances. On account of similar circumstances. On account of similar circumstances. That is that is same law to be applied on same law to be applied on same law to be applied on all the companies. Full stop, single individual may be treated as a class unless it is shown. Single individual may be treated as a class unless it is shown. Single individual may be treated as a class unless it is shown that there are others with similar circumstances. Unless it is shown that there are others with similar circumstances. Unless it is shown that there are others with similar circumstances. There are others with similar circumstances. Full stop. The legislature is free to recognize the degree of harm. The legislature is free to recognize the degree of the harm and the legislature is free to recognize the degree of the harm and to provide the restrictions of its applicability only to specific cases in a clear manner, and applicability on specific cases in a clear manner. Thus, Sholapur company formed a class. Because the Sholapur company formed a class in itself. Because the mismanagement in the company affected production of a necessary commodity. Mismanagement in the company affected Mismanagement in the company affected production of an essential commodity and serious unemployment amongst the laborers amongst the laborers. So in the interest of the community, legislature has treated it in the interest of the community. The legislature has treated it as a class. And made this special legislation. ठीक है? And made this special legislation. Now, कल जो हमने किया था ना टेस्ट ऑफ क्लासिफिकेशन, made a special legislation. ठीक है? So कल मैंने टेस्ट ऑफ रीजनेबलनेस बताया था ना, टेस्ट ऑफ रीजनेबलनेस में ये भी आ गया, एक इलस्ट्रेशन ये आ जाएगा शोलापुर स्पिनिंग मिल्स, चिरंजीत लाल चौधरी, दूसरा इलस्ट्रेशन आएगा अनवर अली सरकार वर्सेस स्टेट ऑफ वेस्ट बंगाल. देख लो, वो कल मैंने डिक्टेट जो कराया था ना स्पेशल प्रोसीजर वाला, तो अनवर अली सरकारी जो था वो लिखो, स्टेट ऑफ वेस्ट बंगाल वर्सेस अनवर अली सरकार. यस,
in this case, Solapur case, when the government is taking the management of the company, is it not acquiring also the possession? Without possessing the company, how will it manage it?
नहीं, possess नहीं होगा. It is इनकॉर्पोरियल वाला जो पार्ट है ना वो एक्वायर करा है.
in the light of Article 1 clause 2, can it be called as requisition of property? Because till the time possession is not required.
इसको ऐसे देख सकते हो, it was a substantial deprivation. Yes, it can be considered as substantial deprivation. हो सकता है. पोजेशन से ज्यादा इंपॉर्टेंट है कि प्रॉपर्टी को एंजॉय करने में भी डेप्रिवेशन है कि नहीं. डेप्रिवेशन इज इंपॉर्टेंट, है ना. सो यस, इट इज अ डेप्रिवेशन. अगर 31 को अगर स्टडी करना है, पर 31 है नहीं आज, 1950 में था, है ना. तो डेप्रिवेशन वाली पार्ट भी उठाया गया था इसमें. चलो अब लिखो स्टेट ऑफ वेस्ट बंगाल वर्सेस अनवर अली सरकार. मैं यहीं तक कराऊंगा आज. अनवर अली सरकार, स्टेट ऑफ वेस्ट बंगाल वर्सेस अनवर अली सरकार. स्टेट ऑफ वेस्ट बंगाल वर्सेस अनवर अली सरकार, 1952 का केस है ये. दिस इज सेकंड इलस्ट्रेशन. ठीक है. सो 52. नाउ Anwar Ali and others were prosecuted under section 5 clause 1. Were prosecuted under section 5 clause 1 of West Bengal, section 5 clause 1 of बंगाल स्पेशल कोर्ट्स एक्ट. एग्जाम में इतना याद नहीं रहेगा, तो आप क्या लिखोगे? दे वर प्रोसिक्यूटेड अंडर अ स्पेशल स्टैट्यूट. देवर कर सकते हो. फैक्ट्स को बोल्ड नहीं करना है, फैक्ट स्टेट करो, मगर अगर एग्जैक्ट ये वर्ड याद नहीं आ रहा है ना, तो उसकी जगह स्पेशल स्टैट्यूट लिख देना. दे वर प्रोसिक्यूटेड अंडर स्पेशल स्टैट्यूट. हाँ, यस यस यस, डायरेक्ट वर्डिक्ट लिख सकते हो. ठीक है. हाँ. सो दिस एक्ट वाज पास्ड, prosecuted under section 5 of West Bengal Special Courts Act. This act provided for a special procedure. This act provided for a special procedure to prosecute certain offences in a speedier manner. To prosecute certain offences in a speedier manner. It prescribed a special procedure. It prescribed a special procedure which needs to be exercised. It provided for special procedure which needs to be exercised. Honorable Supreme Court held that such a law is not violative of Article 14. Such a law is not violative of Article 14 as it stated the guidelines. Not violative of Article 14 such a law is not violative of Article 14 as such a law is not violative of Article 14 as it provided proper guidelines, for classifying an offense, comma, classes of offenses and cases. Classifying an offense, classes of cases or classes of offenses which will be treated under the special procedure. Which will be treated under special procedure. Full stop. Although the special procedure should not be substantially different. Although the special procedure should not be substantially different from the procedure established by ordinary law. from the procedure established by the ordinary law. Intelligible differentia, which is the basis of classification, full stop. कि मैंने कल भी लिखवाया था, intelligible differentia, which is the basis of classification. 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 And the purpose of classification are two different things. And the purpose of legislation and the purpose of the legislation or the purpose of the act are two different things. And the purpose of the legislation and the object of the purpose of the legislation are two different things. And the purpose of the legislation are two different things. The object itself cannot be the purpose of class. The object itself cannot be the basis of classification. Full stop the लिखो. The object itself cannot be the basis of classification. The object itself cannot be the basis of classification. Cannot be the basis of classification of offenses. The object itself cannot be the basis of classification of the offenses. That is, in the absence of any special circumstances. That is, in the absence of any special circumstances. In the absence of any special circumstances which may distinguish one offense from another. Which may distinguish one offense from another. Which may distinguish one offense from another. The speedier trial is more desirable. The speedier trial is more desirable. The speedier trial is more desirable to dispose all the cases. To dispose all the cases. On the other hand, if there are certain offenses like dacoity, there are certain offenses like dacoity, rape, etc. or rights, ROITS, or rights, which call for a speedier trial in the interest of the community. On the other hand, there are certain offenses like so and so which require speedier trial in the interest of the community.
Which call for
speedier trial in the interest of community. A speedier trial in the interest of the community. So these special circumstances, full stop, these special circumstances. These special circumstances. These special circumstances provide a peculiar quality to these offenses. These special circumstances provide peculiar quality to these offenses, which distinguish one from other. Which distinguish one from other. ठीक है, full stop. पैराग्राफ चेंज करके लिखो, the court observed that the law did not lay down any basis of classification. The law did not lay down The court observed that the law did not lay down any basis for classification. Neither any direction was, neither any direction of the same was provided. Neither any direction of the same has been provided. The object of the law is too vague. The object of the law is too vague. Object क्या था? Speedier trial. Is too vague. VAGUE is too vague. मतलब भाई यार, the object of the law is too vague, uncertain, and elusive. The object of the law is too vague, uncertain, and elusive to afford basis of reasonable classification. Object is too vague. ठीक है? So it was held. बस. It was held that the procedure laid down by the act the procedure laid down by the act varied substantially from the ordinary procedure varied substantially from the ordinary procedure. Section 5, which authorizes the government to direct the cases to special courts, conferred arbitrary powers on the government to confer ordinary powers on the government to classify the offenses at their own pleasure. And it is violative of Article 14 to classify the offenses at their own pleasure. And thus violated Article 14. ठीक है? Last line लिखो. Article 14 applies on substantive as well as procedural law. Article 14 applies on substantive as well as procedural law. Article 14 applies on substantive as well as procedural law. Article 14 applies on substantive as well as procedural law. ठीक है? Now I will give you certain handouts. और कल मैं उठाऊंगा. I will be touching on PA नामदार. कल मैं उठाऊंगा. आर्टिकल 15 शुरू करूंगा कल से. ठीक है? तो दो जजमेंट्स हैं, उनको कराने के बाद आई विल मूव ऑन विद आर्टिकल 14, आर्टिकल 15. ठीक है? सो एक केस बचा है हमारा ईपी रोयप्पा, न्यू कंसेप्ट ऑफ इक्वालिटी. मेनका गांधी केस, ईपी रोयप्पा के बाद मेनका गांधी केस, फिर उसके बाद आर्टिकल 15. ठीक है? अब ये दोनों क्वेश्चंस के आंसर लिख के लाना कल, जो मैंने लिखवाए हैं. कौन से दो क्वेश्चंस है वो? दो क्वेश्चन लिखवाए थे ना,
देखिए
एक तो इक्वालिटी इज अ डायनेमिक कंसेप्ट,
पतंजलि शास्त्र
हाँ, एक तो वो है, दूसरा कौन सा था?
article these two expressions to make the concept of equality binding principle of
ठीक है, एक क्वेश्चन लिखो, इक्वालिटी इज अ डायनेमिक कंसेप्ट, इक्वालिटी इज अ डायनेमिक कंसेप्ट, equality is a dynamic concept, the test of equality, the test of equality is, the test of equality is depending upon the prevailing circumstances, depending on the prevailing circumstances under which a law has been made, under which a law has been made, under which a law has been made। ठीक है, तो जो मैंने प्रिंसिपल्स लिखवाए हैं ना, तो वो सारे याद नहीं रहेंगे, मगर तुमको पहले सारे पढ़ने हैं और सारे प्रिंसिपल्स को अप्लाई करके फिर एक आंसर लिखना, अकॉर्डिंग टू विच इलस्ट्रेट करना। केस का नाम याद ना रहे कोई प्रॉब्लम नहीं है, कॉमन जनरल नॉलेज से केस उठा के आंसर लिख देना। ठीक है, सो ये वाला जो तरीका है ना, इससे हमारा यूपी का जो प्रेजेंट डे लॉ के क्वेश्चन सॉल्व होंगे। यूपी में एक टॉपिक होता है प्रेजेंट डे लॉ, प्रेजेंट डे लॉ के बहुत सारे क्वेश्चंस आते हैं जो रीसेंट डेवलपमेंट्स, रीसेंट लीगल डेवलपमेंट से इंस्पायर्ड होकर क्वेश्चन पूछ लेते हैं वो कई बार।
equality सब classification
मैंने एक शेयर भी करा था, क्या था वो?
सब classification
हाँ हाँ हाँ,
state was directed to find out those
फाइंड आउट, यस,
who are actually the beneficiaries.
बट गठन करने को बोला है, मतलब
उन्होंने सब बोल दिया है कि सब क्लासिफिकेशन अलाउड है एंड आप क्रीमी लेयर का कॉन्सेप्ट अप्लाई कर सकते हो।
मगर एससी इस पे तो नहीं लग सकता ना,
तो लग सकता है, पर्पस ये है कि देयर आर सम
मगर एससी में क्लीवेज लेयर तो फ्यूटाइल हो जाएगा, वो तो कंसेप्ट ही खत्म हो जाएगा ना।
क्रीमी लेयर इस पर इस तरीके से है कि सपोज ही इज एन एससी,
ओके
आज की तारीख में ही हैज अ प्रॉपर्टी वर्थ कोर्स,
ओके,
he gets the benefit of reservation क्योंकि इसके पास कोचिंग का every access is there and there is other person जिसके पास कोई access नहीं है, not even he cannot even afford the education fees,
ठीक है,
despite being in SC ST वो benefit नहीं ले पा रहा है, he is able to take the benefit perpetually। इसकी जो generations है they are acquiring the benefit but वो वैसे का वैसे ही रहेगा, तो benefit जो है वो percolate तो नहीं हो पा रहा है, the actual beneficiaries are not getting the benefit, rather the few privileged ones are getting the benefit in the
वो है तो मैं बस
live law पे या कहीं पे।
हाँ हाँ, ये केस में निकाला हुआ है, ईवी चेन्नैया वर्सेस स्टेट ऑफ आंध्र प्रदेश, 6-1 मेजोरिटी पे करेंगे ये तो 14-15 में पढ़ेंगे, 15 और 16 में पढ़ेंगे, तो चलो ठीक है, यहीं तक करेंगे आज।
It's not a game, it's a rich